Welcome back to the Biblical Justice Resources podcast. A couple weeks ago, I was listening to Austin Channing Brown's most recent book, Full of Myself, Black Womanhood and the Journey to Self-Possession. In the book, she recounts a story about the difficulty she had in getting clearance to implement a curriculum on justice, reconciliation, and diversity as part of her role at a megachurch. She tells how, after much effort, she finally got to the point of discussing the curriculum with the CEO, who said he largely liked the curriculum, but that any discussions about power needed to be removed before it would be approved. This story got a vocal from me in response because, after much study, there's something I know to be true. We cannot have accurate, transformative conversations and actions on justice and reconciliation without understanding power. We cannot understand why race exists in the way that it does today without understanding power. And if we aren't actively working to understand the effects of this power, we will miss the impacts and implications of different decisions that are made and how they can seek to consolidate and maintain power. This, along with some other work from Austin Channing Brown and others, has been on my mind with respect to some recent events, including the Supreme Court decision on Louisiana v. Callais. Now, if you will, join us as we talk about how this ruling and race in our society are connected to each other and to an understanding of power. My name's Eric, and this is the Biblical Justice Resources podcast. Our conversation will begin right after this. The Biblical Justice Resources podcast is supported by listeners like you at patreon.com/biblicaljusticeresources. If you're interested in supporting the podcast and helping to resource individuals and the church for the pursuit of biblical justice, please consider giving today at patreon.com/biblicaljusticeresources. Again, visit patreon.com/biblicaljusticeresources to help support the podcast. Now on with the show. As we begin our conversation today, I want to start by saying this won't be a full review of what happened in any specific instance, especially the Callais case. You can find links to some thoughts on the case from some previous guests of the show, including Justin Giboney, Dr. Christine Jeske, and Pastor David W. Swanson in the show notes, along with some links to more complete breakdowns of the case. But briefly stated, as a result of the decision in this case, states can no longer take race into account when drawing the lines for the U.S. House of Representatives districts in their states. In some ways, this is a very specific concern. It deals with one section of the Voting Rights Act and makes a ruling about one consideration for how districts are drawn. But there are connections to so many other things that render this decision remarkably consequential. But there are connections to so many other things that render this decision remarkably consequential. The first piece we'll discuss here is voting rights, or maybe more accurately, representation. You can get a more complete breakdown of the history of voting rights from the links to two different Jamar Tisby videos in the show notes, but suffice to say here, we have needed multiple constitutional amendments and additional legislation in this country to define who is allowed to vote and to attempt to protect and preserve that right. In its essence, this decision does not remove that right. But what is challenged is the aforementioned representation. This is where thinking about power enters the discussion. Following the period of Reconstruction in the United States, voting rights were taken away from minority voters across the country in order for ruling whites to maintain their power and non-ruling whites to maintain a sense of superiority. This is one of the countless insidious things about the system of race. Race was indeed created in order to substantiate the subjugation of black and brown people in the world. But another aspect of this, and of white supremacy, is a way for ruling whites to maintain a level of power over other whites. But another aspect of this, and of white supremacy, is a way for ruling whites to maintain a level But another aspect of this, and of white supremacy, is a way for ruling whites to maintain a level of power over other whites. Through the creation of whiteness as the ultimate, of whiteness as supreme, ruling whites could get those not in power to vote against their own interests and to ignore the commonalities they had with their black and brown neighbors. Anything that was seen as benefiting black and brown people could be rejected, treated with suspicion and disdain, even if it would also benefit non-ruling whites. We return to the present day in this particular ruling. The discussion of power here leads us to look at what it means to draw lines for House districts. From the court's decision, we see that there are still other things that states can take into account without penalty, namely political party affiliation. House district lines are often drawn at the discretion of the party in power at the state level of government. It's hard for me to say which of those states do and don't operate that way as it operates on a state level, but that is in general the way this works around the country. Officials can draw lines to benefit their political party rather than districts which represent the population of the state. If a state with 10 districts and a 50-50 split partisan population were to be redrawn, if a state with 10 districts and a 50-50 split in If a state with 10 districts and a 50-50 partisan split in its population were to be redrawn, the party in power could work to create a map where they are likely to win all 10 districts, rather than drawing maps which would be likely to evenly split the vote. The Callais case came to the court specifically because Louisiana had drawn majority-minority districts after being instructed to do so under previous lower court rulings based on the Voting Rights Act. This brings us to thoughts about de facto versus de jure discrimination. As part of the decision, the court has ruled that claims of discrimination can only be brought based on intent, not on impact. Discrimination and segregation may not be de jure, which is to say, mandated or created by law, but it can still be de facto, or what we see in reality. This is important for many reasons, not least of which because the two major American parties have large racial demographic differences in their makeup. Many more black and brown voters are liberal or Democrat voters. Many, if not most, black and brown representatives are Democrats. With cases about redistricting coming from more conservative, Republican-leaning states, the concern is a future loss of black and brown representation in the U.S. House, which is to say, de facto discrimination and de facto loss of representation. Voting rights may not be taken away, but voices in the House of Power would be. In many ways, this disparity is baked deep into the foundation of our country, but a little more specifically here, this sort of test, one of intent, is one the court has moved toward over the last 40 years. In McCleskey v. Kemp, a foundational mass incarceration case from 1987, which I studied in seminary, the court ruled that statistical evidence demonstrating that racial disparities were present in sentencing decisions could not be used to demonstrate discrimination and an Eighth Amendment violation. Only intent could be used to show this. In essence, unless a prosecutor said, "We are sentencing this person this way because they are black," defendants could not sue for a violation of rights. Defendants could not sue for a violation of rights based on discrimination solely because of statistical evidence. There had not been a successful challenge to this precedent when I studied the case in seminary, and to my knowledge, there has not been a successful challenge in the time since. I see a connection between these two rulings, a racial connection. And a piece of this that has consistently been tapping on my shoulder or active in the back of my mind for the last week rests on this connection. Thinking about different things I've been reading recently, like Austin Channing Brown's work, and Jenny Booth Potter's Doing Nothing is No Longer an Option, I can't help but think about whiteness. I can't help but think about how whiteness is not viewed by whites as a racial category, at least not seemingly until whites feel their power is threatened. I couldn't fully put my finger on the thought until I saw a post from Ibram X. Kendi on social media, where he noted that some whites see, quote, maps for majority black districts to be racist, and maps for majority white districts to be not racist, end quote. Also from Kendi, quote, there are many Americans who oppose the Supreme Court's decision on the Voting Rights Act, but agree with its underlying illogic, that what's predominantly black or Latino or Native or Asian is racial, that what's predominantly white is not, that the policies and practices creating predominantly white congressional districts, that the policies and practices creating predominantly white congressional districts and institutions and cabinets are not racist. And from David W. Swanson, quote, the evisceration of the Voting Rights Act depends on the lie of a race-neutral society. But of course, the United States has never been a race-neutral, colorblind society, and it certainly is not today. There's a large segment of white people in this country asking, when can we finally stop talking about race, who have never had to consider their own racial identity? We've talked on this podcast about white normativity, the idea that what is white is normal and everything else outside of that experience is not. We've talked about how places and spaces that are majority white seek to maintain that reality, that anyone who comes into that space must adapt to and adopt that experience, and that places outside of that norm are considered other and are meant for others. And we've talked about how whiteness seeks to maintain itself and its identity as the norm. But we've also talked about some corrections for this. A robust gospel vision where power over is replaced by power with. The societal fight here seems to be one focused on shrinking the possibility of power with. This is what I think of when I hear declarations that we have moved far enough, changed enough as a society that certain protections are no longer necessary. Efforts to actually equalize the playing field, to provide whatever might be deemed a fair opportunity for all, challenge the power structure's status quo. This is one court decision. Devoid of context, it may seem that there are overreactions to the ruling, that things could not possibly get as bad as some people fear just because of this. But there's a pattern here, a pattern which needs to be challenged. I think often about the phrase, giving a voice to the voiceless. Indeed, there's a possibility I've mentioned this on the podcast before. I've often thought about how the greater issue is that people in power need to be taught to hear a voice that already exists. Here, we seem to have found a combination of the two concepts. The fear that a group is being driven to voicelessness, as having their voice removed from the halls of power and decision-making, is one we need to take seriously based on numerous decisions and rulings over an extended period of time. I'll leave you with this. I don't believe a system which sees whiteness as normative or seeks to consolidate power in this way is one that reflects the kingdom of God, nor does it reflect biblical justice. It seeks division when we are called into right relationship. It seeks exclusion when we see peoples from all tribes and tongues welcomed into the kingdom. And it idolizes its own power rather than worshiping the omnipotent God. So today I pray, may God's kingdom come and his will be done on earth as it is in heaven. Thank you for listening to the Biblical Justice Resources Podcast. This podcast is hosted, produced, and edited by Eric Beck. To learn more about how you can be resourced for the pursuit of biblical justice, visit our website at biblicaljusticeresources.com.